Same here. I'm very well, thank you.
Great. Well done to you and Fola for all the good work.
Thank you so much. And okay, we're live. Good morning, good afternoon, good evening to everyone watching us from every part of the world. You're welcome to another interesting session of the Mediators Hot Set. And today, we have a very, very special person. I use the word special because she's the reason why I'm a mediator today. She's the reason why I'm doing what I love the most. In between the scheme of things, I'm going to tell everyone how I found out about mediation and then the lessons to be learned from having a mediator that is a good ambassador of mediation. So without wasting too much time, we have Mr. Osarieme Ezekiel with us. Abby, can you please do us the honors of reading out our bio so I can get into it? There's so much to be discussed about today. And I'm excited. So shall we, Abby? And before you
Yes,
start,
sure.
we also have Mr. Osarieme's twin sister in the building. I like to call her our twin sister because they're always together. As Mrs. Osarieme Ezekiel. She's also here with us in the building. Thank you so much. And Honorable Justice yes, you're also and Honorable Justice Wale Harriman, Andrew Parsons, thank you so much. So Abby, over to you. Let's do this.
Hello, everyone. Good afternoon, and thank you for joining us today. With us today is Ms. Ezekiel. She's the managing partner at Oakwell Partners, a multidisciplinary commercial and dispute resolution law firm. She has a BA honors in English, an LLB, and a master's in business administration, and was called to the Nigerian bar in 1990. She's a passionate practitioner and advocate of alternative dispute resolution, and qualified as a CEDA UK accredited mediator in 2004. She mediates in civil disputes in areas such as commercial construction, banking, financial services, family, oil and gas, employment, real estate, community, and a whole range of others. She is also certified by the International Mediation Institute, IMI. She is on the panel of neutrals of the Lagos Multi-Door Courthouse, the Enugu State Multi-Door Courthouse, and the Nigerian Communications Commission. She is also on the faculty of the University of Lagos NCMG College of Negotiation, as well as the Standing Conference of Mediation Advocates Nigeria. She is not only on the training faculty of the LMDC, but she's also an active neutral at the LMDC, mediating scores of disputes in diverse areas, particularly during the Lagos Settlement Week in Ikeja and the Lagos Judicial Divisions, when loads of offender mediation takes place. Her firm, Oakwell Partners, has consistently, over the last 3 years, organized annual ADR conferences to promote the use of mediation, particularly in the business community. She facilitates learning for several professional bodies and corporate organizations. She's a member of the Nigerian Bar Association, the IBA, and the Chartered Institute of Taxation of Nigeria. She's also a member of the Civil Mediation Council, CMC. She's a natural leader and a team builder. We make welcome Ms. Osarieme Ezekiel. Nice to have you here with us, ma'am.
Thank you very much, Abby. Thank you, Fola.
Yeah.
It's my privilege to be here. Thank you for having me.
Thank you so very much, man. So Abby, you've read your own bio. Now I'm going to also read my own bio too. You understand? I really do this. Now give you double bio, then so that we can now put her on the special hot seat while the hot seat is getting hotter. So people ask me how I got into mediation, and I always use this as an introductory phase to start off my training. And I met there was this case I was handling 4 years in my former law firm, and it's been a lot of back and forth and everything. And this case was referred to mediation without even telling any one of us like that. We referred to mediation. I must say that is the first time I would hear the word mediation. So for those who know me, I can be a bit cantankerous and all that. Like, what is meditation? So I went to mediation, not with the mindset of settling, but with the mindset of ensuring we did not make any progress. Because for me, I felt I did not, in my ignorance, I felt I did not put in any application. There was absolutely no reason why my case would be referred to mediation. So I got to mediation, and Mr. Osarieme was the mediator. And for a case that we had in court for over 4 years, in less than 6 hours, Mr. Osarieme was able to break that case into pieces, and we settled that case. Ladies and gentlemen, it was like daylight sorcery to me. First of all, I'd never heard of mediation before. Second, having a mediator take time out to listen to both parties to break down that case. And I think the interesting thing that came out of that mediation session for me really was my antagonistic nature, and how at every point in time she did not excuse me from that session. She took time out to educate me on mediation. Every time I tried to say something, she'd be like, Mr. Lade, this is how it should be. So in a way, and what I always try to bring out of this for mediators essentially is that we are ambassadors of mediation. If Mr. Osarieme had shut me out, if she had excused me, if she had not taken time out to explain the process to me, even if we had gotten a mediation, the case settled, I would have not been, I probably would not have been impressed about the whole process of mediation. So every time I say this, I always give kudos to her level of professionalism, because what she did that day was to get a disciple of mediation. And here we are today, disseminating information on the business and the practice of mediation. And I tell everyone that cares to listen, it's not every day you get to be in tune with something that gives you life, something that gives you happiness, something that you do so effortlessly. So one way or the other, I think God used Mr. Osarieme to give me purpose, to give me sense of direction, to make me finally find my calling that I do effortlessly. So I also want to use this opportunity to say a big thank you to you, ma. I want to thank you for all that you do. Thank you for who you are, and just generally bless God for you, ma. So I've always wanted to say this, not to say it to you privately, but say it to you publicly in the midst of everybody. I know this is going to be broadcasted, it's live, everyone can see that your candor, your level of professionalism has actually turned me into who I am today. And I say a big thank you to that. Thank you, ma. So we cannot get
Thank
into
you very much for those kind words, those glowing words, Fola. I am humbled, by those words, and thank you very much. Grateful to God for the opportunity. Thank you.
Thank you so much. Okay, now, ma, like I always say, the journey is as important as the destination. How did you find out about mediation? Can you please take us through the journey of how you found out about mediation and how you are into mediation now? Thank you.
Okay, thank you. I'll start like this. Well, I had always wanted to study law, but I had my first degree in English in 1984. Thereafter, I went to study law. After I studied law, though, I realized quickly that I didn't want to be a litigation lawyer. So I commenced my career, my professional career, that is, in the banking sector, in 1991. I, over time, worked in various sectors of the banking industry, and then I found myself appointed as Company Secretary Legal Advisor in a commercial bank. As Company Secretary Legal Advisor, it was very clear, it became even clearer, the implication of litigation on business or, commerce or commercial transactions, if you like. I found that it had serious implications by way of cost, time, damaged relationships, frustration to the business, frustration to the parties. And I knew that there just had to be, a better way to do things. For me, the legal department of any organization like a bank is always seen as a cost center anyway. So for me, my desire was to bring down the cost. I mean, we had a litigation portfolio that ran into thousands of cases. So I was constantly seeking ways to bring down, cost and prune down our litigation portfolio. Then one day I was talking with a friend, and in the conversation, he mentioned to me, also a lawyer, he mentioned to me, that there was a new process called mediation. We were talking about, resolving disputes and being in court and all of that. And he said, that CEDA UK was in Lagos to carry out the first training. And he said he would find out if I could, if they hadn't started or if, I could still join that. Anyway, long story short, they had just finished the Lagos training, the first certification training for mediators. But he found out from NCMG, that they were going to have a replica in Abuja. And it was like, and they had said, if I could find my way to Abuja and pay, then I could join the Abuja stream, which was like 2 days from there. Anyway, that's how I found my way to Abuja, did the certification course in Abuja, and immediately after, or soon after, as soon as I got certified, I was invited to the CEDA Train the Trainer program. After that, as soon as I got back to my organization, I redesigned our resolution processes, in our agreements. I made sure that we, in the legal department, included mediation as one of the processes for resolving disputes, because I was like, how come it was all this while litigation and arbitration? But of course, it was clear that, mediation was new, nobody really knew about it. So started my mediation journey. Now, I tell you what happened to me during the training. As I got to that training, I knew that I had found my niche. I knew that, I absolutely loved the training. I absolutely loved what it was about, what mediation represented. I took to it like a duck to water. I loved the non-adversarial process of mediation, the fact that it was ideal for commercial, relationships. You could use it to resolve disputes effectively, their relationships, which was key, and commercial transactions. In the bank industry, that was key because I saw relationships turn. You'd have a customer of the best in a branch. Something could be a misunderstanding, and the whole relationship would turn sour, and we will end up owing the bank so much, it was just fantastic. So there started my journey into mediation. As soon as I did the Train the Trainer program, and NCMG, LMDC invited me to join in the sensitization, program for lawyers at the time, and it was always pro bono because lawyers didn't know about it. There was so much resistance, to mediation at the time. Lawyers didn't know about it. In fact, they would laugh, when you talk to them about mediation, and to them it was like a waste of time. So we started that, and then even in my career, when I left, when I became head of commercial banking in bank, I helped in developing dispute prevention, because in discussing with clients, I would always use negotiation to ensure that relationships or situations didn't degenerate to actual disputes. If there was a conflict, we quickly, stepped in, and I did that. And so when I left and went into, started my own private commercial practice, it was a no-brainer. We currently have, I work in a firm that offers a full-blown or full-service ADR service in addition to being a commercial outfit. And so, in our commercial law firm, in drafting agreements or negotiating agreements, we found that a lot of times, because we already had the habit and the practice of having a full-blown dispute resolution clause in all our agreements, we were always, having to explain to lawyers on the other side and even the clients, because they had no understanding or no knowledge, or limited, should I say, knowledge of mediation. Because then when you say ADR, people will say, oh, I know ADR. The lawyers will say, I know ADR, A, D, and R. the A to them was arbitration. All they knew about ADR was arbitration. So we always, had that. So, I found that, there was limited knowledge about it. So we continued, and we then thought, what do we do, to in our own little way, promote mediation, the knowledge, the awareness, the usefulness of mediation. So we started what we call the Open Mediation Conference, and then, went on to create the Open Mediation Center, which, like I said, is a full-blown ADR outfit where we bring together mediators, arbitrators, cost experts to deliver any intervention in business disputes. So, thus began my journey into mediation, and I haven't looked back. I mean, mediation, I think I'll stop there, so that I don't go on and on and on about it. But I found my niche, and I found a very effective way of helping parties arrive at a solution. Paula was talking, and he was saying that, in using mediation, he feels happy because he's intervening in parties' situations and is helping them, get better outcomes. That's exactly how I feel. I will always feel about mediation, because I just couldn't, quantify the impact on people. Whenever I mediate disputes and I help people, arrive at solutions, or when I facilitate and parties arrive at a solution, there's always this feeling of joy. You feel that you have helped people move forward, move beyond those disputes, move beyond the hardening of their positions, that usually will take them or keep them in court forever. So for me, that began my journey to mediation.
Thank you so much. And it's funny, this explanation has actually answered 3 of my questions. And because right here we have a cross-section of seasoned mediators, young mediators, and interested parties' desires of knowing what the concept of mediation is. And what I'm almost putting the cart before the horse, but for everyone listening to you right now, desirous of starting off a mediation practice, using the challenges you had when you initially started off, because I'm sure if we look at the challenges they say they have now in 2021 to the challenges you had close to, if not up to 10 years ago, what lessons can you say you were able to learn from it to give to them while they are all taking steps to set up their own private mediation practice? Because before you answer, because for someone like me, I never had a conversation of sitting down with you to say, Mr. Osarieme, please be my mentor. I followed you closely. I looked at your template, noticed there was an equal partners. I went ahead, I set up Fortefa partners. I noticed you set up an equal mediation center. I went ahead, I set up a Fortefa mediation academy. So if you notice, I noticed you had your mediation conference. I went ahead, I also had my own mediation conference. So you can see, there's this saying, follow who know road. So yeah, like whatever Ms. Osarieme does, Ola would also try to replicate. So based on the challenges you had when you started off to where you are right now, what advice do you have for people who want to go down that lane with you?
Okay, the first thing I would say though is to thyself be true. Why do you want to be a mediator? Is it just a new fad? Is it a new area and just want to follow the bandwagon?
Yeah, I'm sorry. Please, can you answer that question in 3 ways? The first, as a mediator, the second, as a mediation advocate, and the third, as a trainer. It's still the same question, but I know they would have different angles to it. Sorry about that. Thank you.
Okay. Well, it's like I said, it's good to know where your passion lies. And I said, to thyself be true. Why do you want to be a mediator? Is it just because you see it as a new area and an opportunity to make money? Because yes, money can be made from mediation, but you really wouldn't go far, if your interest in becoming a mediator is basically just to make money. If you're passionate about it, because there are skills you need to have as a mediator. You must know your temperament. The same way people say if you know that you'll be traumatized when handling a particular type of dispute, so steer clear away from it. The same way an individual should know their temperament. Am I patient? Can I, listen to parties? Can I empathize with people? Because to be a successful mediator, there are skills you should have. You should, be able to listen. You should be able to empathize with people. And I don't want to, go too deeply into that yet. So, at the time when we started off, or when I started off my mediation career, it was very clear to me that this was an area I was passionate about. That I was passionate about trying to help parties arrive at consensual, or desired outcomes when they were in dispute. I was passionate about helping parties move beyond their positioning, their hardening, because you talk about conflict, and you know that there's a difference between conflict. Well, these days I said there's a difference between conflict and dispute, because when there's a difference in opinion, you start off as a conflict, and then it degenerates into a full-blown dispute. So you then know you're there, to resolve it, or both of you go into the abyss. And it's funny when you are in some mediations, you see where people started from. They started off probably as best friends or good business partners. And when the dispute, arises, they are, so polarized. So, I would advise, that be passionate be sure that you are passionate about it and you know exactly what mediation is. As a lawyer, people wear different hats. It's like when you have a judge, you find that sometimes a lot of judges, are mediators, and some of them say it's difficult for them to put off the hat, of a judge when they're in mediation. And even for some of them, even when they've put off the hat, people still see them as judges, and like, this judge is here. Are we in mediation or are we in court? And that's why you find that in the States, a lot of retired judges are mediators. You find that you have a lot of retired judges as mediators. So, know yourself, understand what mediation is, and be ready to give it your best shot, so that so that you know exactly what it is that you are doing. I always also say that when you understand mediation and where it's coming from, or understand its use. If you know that you want to be a good mediator, and what's the word? You want to be a good mediator, and you want to have help parties always, or increase the success rates. Then be ready to learn to acquire skills, and then also these days I see that a lot of institutions are churning out mediators, and a lot of them do not have opportunities for practice. So you ask yourself, how do they garner the experience that will help them to be better mediators in that field? So I always advise the young lawyers, try to find mentors, attach yourself to mentors, and see if with the approval of their parties, you can sit in on their mediations so that you can learn, because you cannot go from acquiring certification, or learning or qualifying as a mediator immediately into practicing, as a mediator. It's important that you acquire the skills and also have the opportunity to practice. So that's why when you go to an institution, and that's important, for the young lawyers here, it's important that when you want to be a mediator, or when you want to qualify or be certified as a mediator, go to find out about the institution and go to one that will afford you an opportunity for practice in the process of certification. So that, because practice is key. So for me, I would advise that from the challenges that I went through at the beginning, what is key is that you be passionate about it. Because sometimes it might seem like a thankless job. Sometimes you might have to do it pro bono. Sometimes you might feel that, it doesn't give you the kind of income, but the truth, of the matter is that with mediation, time is always of the essence. I always say to lawyers, who are die-hard litigators, that the time you will spend, carrying out a brief in court, 5 years, in 1 year, you could have turned over like 5, cases, or helped to resolve like 5 cases, and make your money and move on to do other things. So I don't know if that answers the question as you asked it, but those are my, few suggestions. The important, like I said, one important thing is to be passionate about it, to understand mediation, understand the process, and have a desire to help parties achieve a win-win outcome, a desired outcome, because as you know, parties always, in mediation, parties want a win, parties get a win-win outcome, and that's why mediation, is thriving, or it thrives, and that's why it's different from the other types of dispute resolution processes.
Okay, Paula, does that answer your question? Hello?
Yes, it does. But maybe one question you can please add to the question I'm going to ask her is are the ethical issues surrounding mediation?
Should I show you my tab? Can you
because
see
because
it?
you see
It's right here.
what Miss Osarieme doesn't know she has done right now is that explanation has opened a floodgate of contemporary issues surrounding mediation. So I won't be surprised if the ethical issues vis-a-vis training, standardization, and even having a body of laws guiding mediators to come into place. But you go first. You go first, and I'll take it up from there.
Yeah, it's actually what she said. You mentioned, that you mentioned about the knowing yourself and knowing this is something you want to do, and knowing you have the capacity to do it. So now, from that, I have 4 questions here. So now the mediator's mindsets. I would like for you to make a comment about that, because then that would, lead to the next question.
The mediator's mindset. Do you mean what is the mediator's mindset?
Yes, please.
Well, simply put, I would say that the mediator's mindset, would just be to explain, who a mediator is. Who is a mediator? A mediator is a third-party neutral that assists parties or facilitates conversation or discussions between parties to a dispute, helping them arrive at a desired outcome. So a mediator, to have a mediator's mindset, you must be impartial. 2, you must understand, the workings of mediation, such that, you are able to listen to the parties, because it's very important. Listen to the parties, and guide them, towards arriving at the desired outcome. So to have a mediator's mindset, would be, to understand what mediation is. And, understanding mediation, means that, I would use an imagery or an image. And I learned this, to understand mediation, you can liken the court, to the court process, to using a sledgehammer, on a knot, for example. But if you take mediation, you can say, oh, mediation, you have used a nut cracker. The tool is a nut cracker. And in trying to crack the nut, you take out the nut and preserve the shell. So in having a mediator's mindset, your mindset is to help parties arrive at a desired outcome, arrive at a solution. How do you do that? How you do that, is the process, understanding the process. knowing that you must be impartial, understanding, for me, a mediator's mindset is understanding mediation and understanding the process, because then you understand that, look, it's a confidential process. My role here is, one of the facilitator to help parties by listening to the parties and guiding them, towards arriving at the desired outcome. So,
okay, great. I have like 3 more questions, or 4 more questions actually, but Andrew has a question here, and I would read his question. Thank you so much for joining us, Andrew. He says he would like to find out whether mediators in Nigeria are aware of the move towards compulsory ADR in the UK.
Sorry, the line went off. You would like to find out?
He would like to find out about if mediators in Nigeria are aware of the move towards compulsory ADR in the UK.
Can Andrew
Well,
expand this narrative
so.
a bit? I'm sorry, Andrew, can you please unmute yourself to expand this narrative a bit?
Can I just say, as Mary, that wasn't a question just for you. It was kind of a general question. It's good to hear from you, by the way. I love your passion about mediation.
Thank you, Andrew.
Yeah, but in terms of, I don't know what's going on in Nigeria. I'm based in the UK, but I do international mediation sometimes. So I'm not sure whether it's a general question, really, about whether in Nigeria you're aware that there's a move, certainly in UK and in other jurisdictions, towards compulsory mediation in certain types of cases. So, I mean, there's a Civil Justice Council report that came out here last year. I say last year, no, it's not quite actually. It's 31st of July, isn't it? So, almost last year, which is suggesting that there should be compulsory mediation, or not mediation, ADR processes, which is the whole range of what it is, not just mediation. So the whole suite of stuff, such as early neutral evaluation, mediation, all sorts of things that I don't know whether you, obviously I know I'm well aware of the multi-door courthouse in Nigeria. So some of the judges there effectively are maybe acting as mediators. They're certainly acting as conciliators, I think, under that system. Although shoot me down if I've got that wrong, but I've always admired that system. But it could be, for example, expert determination. It could be all sorts of ADR processes. But the point is that the idea that before going to a court, compulsory ADR, however you describe ADR, should happen. So you can't even get before a judge in the UK here. That's the idea, unless, well, not small cases, of course. We're not talking about small claims, but anything of significance, you can't get before a judge unless you've used some kind of ADR process, and not just going through some, not just tick the boxes. You have to prove that you've done it. Anyway,
Yes,
I don't know. It wasn't a question for you particularly. I was actually opening it up to everybody who's here attending, just to see what they felt. But I mean, of course, answer first. I mean, I'm quite happy. I'm interested. I'm genuinely interested about what's going on in Nigeria, because I know there's a cultural thing that really matters about culturally to resolve disputes without going to court. That also is why I think in not just Nigeria, but in also other countries, it's important that that people don't go to court, and you as a mediator, you are there to help them avoid them doing that.
Yes, thank you. I know it's not a question, just as a follow through or a little response, to what you said. Interestingly, in Nigeria, at the moment, particularly in Lagos, maybe I should say, the civil procedure rules, new civil procedure rules, provide for parties to explore the ADR track, to go on the ADR track, like you say you have in the UK, to see if the disputes can be presented or can be resolved through any of the ADR mechanisms before coming back to litigation or coming back to the court. So this, happens. This is happening in Lagos, at the moment with the Lagos State civil procedure rules of the court. And I happen to know that, well, I mean, in the UK, from statistics, it would appear that the success rate for mediation is in the region of about 97%, if I remember correctly from what I read. For me, and mediation is mainstream actually, like you also said in the UK. For me, I would like, as an emerging trend or a futuristic thing, for mediation to be made, mainstream here as well, not the alternative to litigation, not even going through for specific type of disputes. And those disputes to me would be commercial disputes. My take is for commercial disputes, there's no need to beat about the bush. What's the best, method? I think, that's my view. I think that, mediation should be made mainstream, for resolving certain types of commercial disputes, like you say you have, elsewhere. But yes, here, sometimes you have the ADR track, which makes going to ADR mandatory before the litigation option is explored.
Okay, great. Thank you so much. Thank you, Andrew. I know you have to leave us. We appreciate your spending time with us. Okay, so now my next question is mediators, the mental health of a mediator. That's something I would really like your, input.
What do you mean, the mental health of the mediators? Do you mean mediators should go through a psychiatric evaluation before they get certified, or I want to understand the question.
No, so, well, that might actually not be a bad idea, considering the climes we live in. I mean, there are times I'm in traffic.
What is the foundation of your question, Abby? I want to know what is the foundation of that question?
No, I mean, I've seen, and I'm just going to not mention any names, I've seen a mediator in traffic behaving in a very, very, in a non-mediation, I mean, behaving not like a mediator. So that got me thinking, so now if this man were to have whoever it was, the guy in the other car, come into him, or have his matter assigned to him, how would that play out? But that's one question. The other part of the question is, when we mediate and we have parties come in with all their woes, for lack of a better word, the disputes and the conflict, I don't know if it's just me, we tend to, or let me say, I tend to absorb some of that. And I find that and where I work, I mediate at least 2-3 matters a day. By Thursday, I need a mental vacation. I don't want to, and I'm sure this is not just mediators, but I find that I remember when I was going to court and I had a matter, I would be asleep, but my brain would be thinking. I don't know if anybody else here has experienced that, but as a mediator now, it's on a different level. I find that I'm actually, there's mental fatigue. I don't know if anyone else has experienced that. So that's the other part of my question with regards to the mental health of a mediator or of mediators.
Okay. I'll take the second part of your question, which is the mental fatigue. It's only natural that when you're overworked, you it shows. But one major thing we must remember as mediators is that, when we're taught, or when we were taught, the first thing we were encouraged, and the one thing that we keep teaching and we keep encouraging ourselves to have is, because, you need the energy to sustain you as the mediator through, your mediation sessions. You, as mediators, you cannot afford to allow your energy wane, or your mental state color your responses to the parties. Otherwise, it will show, and parties could pick up, it could, come across, in your responses to the parties, and parties could pick it up. Sometimes it comes across without you even realizing. So it's always good, when we find ourselves in such situations where we feel that we are mentally drained, to take a break. Is it that, if it's during the mediation, we can ask for a break, maybe a 30 minutes break, so that we, as the mediator, you can let your head down, you can refresh and reinvigorate and come back and recoup, or if it's the parties, because sometimes it's the parties, you can call a break, call it quits, and come back on another day. So, it's really no excuse for us as mediators, regardless of how stressed we are. We cannot afford to pass it on to the parties, in mediation, or allow it color our mediation sessions. Once we feel that we are not on top of it, it's advisable, or it's best not to proceed with that mediation. Take a break, and then come back. That's my take on that, because your energy level you need to be on top of it. You need to listen, because as a mediator, if you're tired, you wouldn't listen to the parties. And you know how it is with communication. If you're talking to a party and you're not really listening to the party, you won't even be able to summarize what the person has said. You really wouldn't even hear, and you will be saying the exact opposite of what the person, that party has said. And that can be a major hindrance to settlement, and the party trusting you, because the party will feel, oh, this mediator is not even listening to me. What kind of process is it? I don't want to go ahead with it. And it could, it could be one of the issues or the reasons why some disputes don't settle, because I've seen parties clam up. When they feel the mediator is not listening to them, they just clam up. They refuse to say anything. When you ask them, to make a contribution or make a comment, they tell you they have nothing else to say. So as a mediator, that gives you more work, because you now have to try and draw them out, get them to relax, get them to trust you all over again, and then start talking to them and assuring them, that you are listening to them or you are with them. And, so you can't afford to have outbursts. You can't, there are some things that, we can't afford to do as mediators. Those are not allowed. So, there are professional, expectations of us as mediators. So the best way to do this is to, call it quits. And that's why I guess, we're giving non-disclosure forms, or disclosure forms, if you like, that's what it's called, for you to say if there's any reason why you can't proceed with a mediation when it's been assigned to you. Because sometimes, like I already said, sometimes a dispute brings memories to you that you would rather avoid. So when you know that, you will be subjective, why carry on with it as a mediator? You should, recuse yourself from it, refuse to handle it as a mediator and move on, because in your role as a mediator, you must be 100%. Remember, you're trying to help parties resolve, a real life issue, that affects them. So.
Okay, so you're not going to answer the first half.
Well, I guess most institutions that certify mediators do a background check. When I say background check, I guess they interview the parties or the individuals who apply to become mediators. And while it's difficult to assess or decipher the extent or the mental balance of an individual, I guess in the course of interacting with that individual, whether in training or as a mediator, one would know a mediator or an individual that is not 100% there. And that would be something for the institution, to deal with or to handle, or the individuals to handle. So I don't know that, you could ask parties or individuals to do a mental check because they've come to your institution to get certified. I'm not aware that it's been done anywhere, but I might be wrong. But I guess there are other ways
of checking.
In being certified, in becoming certified as a mediator. You carry out role plays, and you are assessed and all of that. So you pick up these things. These things are not difficult to hide, and they end up impacting on the assessment being given to such individuals. So, and let's say that such individuals manage to mask those tendencies, they will come across in their life, in their journey as mediators, and it won't be a secret. It'll be well known that mediator is not all there. So.
Okay, thank you so much. I have two more questions. I would like your input or your view on mediation etiquette and ethics in our client.
Thank you very much. Ethics is very key, in mediation. Ethical values are the things that make us who we are. And mediation has, its ethics, and also there's an etiquette. I will start with the etiquette, if you like. The etiquette, one of the etiquettes is what we just, talked about, being able to listen, being all there, and not carrying out your frustrations on the parties or your emotional burdens on the parties. So a mediator is expected to be calm. A mediator is expected to be polite to the parties. A mediator is expected to listen to the parties. A mediator is expected to be impartial. A mediator is expected to have good body language, maintain eye contact, draw out the parties, make the parties feel welcome. A good mediator, is supposed to have the etiquette of, confidentiality, such that you only divulge what it is that parties have asked you to divulge, and you ask them. These things to me are etiquettes, and one key thing also is dressing. Comportment is one, like I've said. Dressing is another. As a mediator, how do you present during a mediation session? I know that we've had, at various fora with colleagues in the mediation industry, talking maybe during the settlement week at the Lagos Multi-Door Hotel, the idea of whether to wear Nigerian clothes or Western clothes have come up. For me, it's not the fabric. For me, it's the presentation. Do you look professional? Because a mediator must turn out looking professional. So if you're wearing a dress, how is the dress? Is it open all the way around? Does it expose your body? Because you must comport yourself properly, physically, and with what you're wearing. Remember, you are seen as the mediator. You are in charge. You hold the chair. Is your show, and you want the parties to respect you. So how do you comport yourself? If you go, into mediation looking, all disheveled, the kind of respect, or it's unlikely that you carry the authority that you should carry. So for me, the mediator's etiquette, can be seen from, the dressing, the language. How do you speak? Do you speak? Do you communicate well? The language, the comportment, the physical outlook, all those things are important in terms of my way of etiquette. Now, when it comes to ethics, very, very important. Now, mediation is a process where we say that the mediator is impartial. So the mediator does not decide for the parties. So it's, except the parties have no understanding, it's unlikely that they may want to compromise a mediator. It's important for mediators to have ethics and to be very, very firm in dealing with issues that would, could compromise their ethical, positions. For example, we've been told of, I know of a mediation, a mediator in a mediation who was offered an envelope, should this happen, how do you deal with it? How do you deal with a party who tells you or who tries to insinuate that he would like for you to, or they would like for you to help them resolve their dispute? So ethics is very important, and it's important that a mediator must understand the ethics of the profession to be sure that they don't get compromised in terms of their positioning. Anything that will compromise your position, or your conception as a mediator should be dealt with decisively, particularly before the parties. So if a party is saying to you that, oh, okay, and that brings me to one important issue. I mean, if you know, and this is talking about ethics, if you know that parties to a mediation are well, or a party to a mediation is well known to you, it's only ethical that you bring this up and let the parties know. Yes, you are a neutral and you do not help parties resolve, but there's an implication, there's a misconception that could be created when one party realizes that, oh, so you are the sister of this person, So it's always good, to say things like this beforehand so that your neutrality is not brought to question. So when looking at ethics, what is important is to be sure that as a mediator, anything that will impugn on your neutrality, on your professionalism is done away with.
Okay, thank you so much, Ma. You had mentioned this earlier, and ADR has been misconstrued to be arbitration dispute resolution, but it's actually what it is alternative dispute resolution. Personally, I have an issue with the fact that the word alternative is used. So it's like saying sugar versus stevia. So I would like your take on that. And then I had a conversation with someone recently, and it had to do with unsuccessful mediations. I personally don't believe there's any such thing. So I'm just going to lump those two together, and then Fola, it's over to you.
All right, thank you, Abby. Yes, alternative dispute resolution. I agree with you. My take is alternative to what? Alternative to what? And which is why I mentioned, when Andrew made that comment, that I would like to see mediation become mainstream in Nigeria. For me and for us, in Ukwel Mediation Center, we do not refer to it as alternative. We refer to it as accelerated dispute resolution, because, that's what it is. It's more appropriate. When you say alternative dispute resolution, it gives the impression that, oh, it's just a, it gives it, a kind of disadvantaged, interpretation. Like, oh, okay, it's just an alternative to litigation or something. No, mediation is, arbitration, is particularly mediation. It's an alternative to, and it's in its own right, it stands just as well as, litigation does. Arbitration stands just as well as litigation does. So for us, like I said, it's accelerated because it's faster. I stopped calling it or stopped referring to it as alternative dispute resolution. I always say accelerated, or I say amicable dispute resolution. Because in mediation, parties reach an amicable resolution. So for me, it's amicable dispute resolution. Saying alternative dispute resolution always kind of disadvantages it, because the question you would ask is alternative to what? You know. And then the second question, please remind me.
Unsuccessful mediations.
Right. I don't think there's anything like an unsuccessful mediation. Absolutely no. Particularly when parties, well, if parties do not resolve, it doesn't mean that the mediation has been unsuccessful. I always say that the fact that parties have not reached resolution in a mediation does not mean they cannot settle outside the mediation. And I have various situations like that. I've had various situations like that. Parties didn't resolve in mediation, but before they went to court, they resolved. So for me, in handling a mediation, when parties don't resolve, I always tell them to keep talking. I encourage the parties to keep talking. I encourage the lawyers to keep talking, particularly in the time between when they finish the mediation and when the court, gets to hear, the dispute. I always say keep talking. And you find that because they have, engaged during mediation, they have spoken, they've negotiated, or, they've listened to each other. Remember that in mediation, parties who in litigation would not have sat round the same table, would not have been breathing the same air, would not have been in the same space, you'd have had the opportunity to come together. And I always say to parties in my mediations that the fact that they are seated round the same table is half of the work done, because, it provides an opportunity for them to listen to each other. Sometimes parties may never have even really heard each other on what was the cause of the dispute. And that mediation session in the opening provides them with an opportunity to even hear what actually happened. So it always helps parties, such that when they don't resolve during the mediation, sometimes they go on, and even while they're in court, the one party may say, okay, you can talk to the lawyer and say, okay, let's talk, and they resolve. So, there's nothing like an unsuccessful mediation. Parties didn't resolve in the mediation, but it wasn't unsuccessful. The issues that are, or the points that I've ironed out, the fact that they've been able to listen to each other, goes a long way in helping them, mend fences and heal, because in mediation, they would have had their day in court, they would have expressed, and vented, and that goes a long way towards helping parties resolve, their disputes, whether they end up reaching consensus or not.
Great, thank you so much. I agree with you totally on that. I want to take the questions in the chat.
No,
there's a question.
No, let's wait a bit, Abby. We'll take those questions later.
Oh, okay, that's fine.
Yeah, okay. But before I speak, we have Mrs. Fadike Adekbeto's hand up.
Her hand is up.
Can you please unmute yourself and ask your questions, please? Briefly, please. Mrs. Adekbeto, could you please ask your question? I think she has unmuted herself.
She has.
Okay, I guess we'll just wait for her to come back. Okay, so Mr. Osarieme, I have a question, and it's in form of a comment. I would just like you to, if you agree, you can please expand the narrative, and if you disagree, you can please let us know why you do. Now, it's not exactly a contrarian view or me trying to be a devil's advocate here, but I hold the belief that the concept of mediation is a bit foreign. Now, people talk about culture and mediation. People talk about mediation being a lost legacy within the African context. And as a student of history, I've gone back into history. I've looked at the concept of ruling under the Yoruba traditional system, where there's always an Oba. Oba has a council of chiefs. Then when people have issues, they come and meet the Oba. Fine, there's a sense of justice because the Oba listens to what they have to say in connivance with the council of chiefs. But ultimately, the Oba takes a decision. The Oba's decision is final. The Oba does not balance. If we are going to look at the etymology and the concept of mediation, vis-a-vis being a mediator, to listen to what A and B has to say and assist both parties towards an amicable resolution. It is not like that. I've also looked at the Igbo system of rulership and the Hausa system. It's almost the same thing. There's always that traditional head. There's always a council of chiefs. They all listen to what the parties have to say, and they take a decision. And which is why when the colonialists came to Africa, it was easy to bring in litigation, because what they did was to just more or less put a judge to take over when things became commercial. So a judge more or less took the place of an Oba who would listen to both parties, and they were able to build this narrative of commercialization till where we got to where we are right now, where everybody has been somewhat programmed, subconsciously programmed to take decisions, which is why even if you look at some of the mediation sessions we handle, when it has to come to using either evaluative or facilitative, you find that parties find it very difficult to come to the decision on their own. You have to more or less decide on which style you want to use. And I think the closest we've ever had to some semblance of mediation back in the days would be religion, in the form of counseling, where either the priest or the bishop then would admonish parties towards making peace. So, at what point in time in the African concept of history, culture, religion, spirituality, did we ever practice mediation? Now, don't you think, and this is where this question comes into play, that maybe mediation being a foreign concept, so to say, quote unquote, my opinion, might probably be one of the reasons why it is not taking its desired place as an effective system of dispute resolution, because people are not used to that concept. So I struggle with understanding when people say mediation is innate. We've always had mediation in us and all that. I'm not talking about the concept. I'm talking about a scenario where there is that facilitator who does not impose on himself what he or she thinks a concept of justice is, but that looks at what A and B need and comes to that amicable resolution of some sort. So the question is this: within the African context, don't you think mediation is a foreign concept? Using the analogy I just put into play and tracing history from then up until now.
All right, thank you for that. Going by your explanation, indeed it's true that we traditionally, we have institutions that have always been in place to help parties arrive at, a solution to, their disputes or their differences. Typically, we like to be, as, let me talk about Africans. I don't know about elsewhere. Let me talk about, Nigerians, because I know about us. We've always had, the traditional way, like you said, because as a people, we like to be told what to do. As a people, we defer to authority too, And so it's true that people would, when there's a dispute, will expect to be told, do this, do this, do this, which is basically what conciliation is, and that's the difference between mediation and conciliation. And mediation, in its strict sense, as a word, you would say it's foreign to, to us if you look at it like that. But would you really say it's, much different from that traditional part? Because mediation, in mediation, there's a role, like you said, for evaluation, for an evaluative, for the evaluative style, as well as the facilitative style. Yes, we practice most of the time the facilitative style. I believe that, there's room for a hybrid, and it depends on the dispute. There are disputes where you have to, give the evaluative style a little nudge in it. And I find that, there's this new approach. I guess it's always been there, but we say it's new. And that's why I wouldn't say mediation is totally new to us. As a word, mediation is new to us. But in style, I wouldn't say it's completely new to us, because mediation has a gossip approach, if you like. And the first time I read a gossip approach. I was like, gossip approach, I wouldn't use that word, but that's it. And what is that? It's giving scenarios. I mean, why do people watch Big Brother and all of those, real-time programs? They want to know what's happening with other people. They want to know how other people reacted or what happened to other people in similar situations. So the gossip approach, allows you as a mediator to give examples of similar happenings or occurrences, to the parties to say, in a mediation that I handled, without being specific, this happened. This was it, and this and this and this and this is what they decided. Parties want to hear that. I find that people want to know because that's what they ask you anyway in mediation. What will you do? They ask you, what will you do? And that's why they want someone to tell them what to do. But then again, when you tell them what to do, then they hold you to it and say, oh, you told me, to do this. So you want to be careful, when you are giving an opinion. So that's why that gossip approach works, whereby you give scenarios, you give examples, saying it occurred like this in this situation and in that situation and in that situation. Parties, are motivated towards arriving at a similar, outcome, because they say, I see, in that, they want to be guided. So while you are not telling them, as mediation, requires, why you are not telling them, or why you are not deciding like a judge, which is what, our traditional systems, would require, it also helps them. I agree with you that it helps, when parties are told what to do, but believe me, it depends on the kind of dispute. The type of dispute is not a one-size-fits-all kind of this thing, because there are some disputes where people want to be told what to do, which is why they go to conciliation, which speaks more to our traditional methods. But yes, mediation might be different in style, in the sense that the mediator doesn't tell you what to do, but is more appropriate for certain types of disputes, because in those type of disputes, if you tell the parties what to do, they're not going to accept it. They want to arrive at those outcomes themselves. They want to see how it's going to work, and that's the attraction. And that's why they haven't gone to litigation, where you would have a win-lose, but they've come to mediation this style, that enables them thinking through, particularly in commercial transactions, that enables them thinking through and arrive at what they feel will work best for them and they can live with. So, for me, that's, my contribution. That's my take to that. Yes, our traditional styles, which is why people go to the police. And I always say, why would you take, a civil case to the police? But, we're used to authority, and that people will go to, that's why people will go to the police. That's why people will go to the Oba, and want the Oba to resolve their disputes for them. Now, it doesn't mean, that mediation is not gaining ground because it's foreign to us, and we're used to, being told what to do from our traditional, methods. It just means that dependent on the type of dispute that depending on the type of dispute, mediation will be most and more appropriate, whether it's foreign to us or not. And people who value this, will always value mediation over the kind of process that affords for one party to, lay down the markers or tell parties what to do. So that's.
Thank you so much for this. Now, the second contrarian view I have about something before I hand over to Abby is how undilated people don't see the concept of culture in mediation. Now, I hold that strong belief that ultimately let me rephrase that. We have the African concept of mediation, which I think is different from the European concept of mediation, because ultimately, whatever it is we learn from international organizations, we have to bring it home to the culture, infuse our own culture into it and all of that, which is why one way or the other, I would rather go for homegrown trainings in mediation than international trainings in mediation, because I believe that An European cannot teach me about the concept, an African concept of mediation. Now, my question is this. Don't you invariably then think, based on this standpoint of mine, that we cannot exactly say we have a universal concept of mediation, and probably just come to terms with the fact that even though we are practicing mediation as the word mediation, but ultimately there's an African concept of practicing African concept of mediation, and there is an European concept of mediation. I'd like to hear your thoughts on that. Then Abby, over to you.
Okay, thank you for that. For me, I would, beg to disagree in the sense that I'm from, your position that there probably is a universal or a foreign and an African. And I tell you why. For me, there's only one concept of mediation. There's only one process of mediation. Now, how that process is worked on, utilized to help parties arrive at their outcome is the distinction that you're trying to make. Because mediation is still mediation in Nigeria, in Singapore, in Australia, in the UK. The process is still confidential. The mediator is an impartial third party. The mediator does not decide for the parties. All these are universal, and it's the same everywhere, all over the world. Otherwise, it's no longer mediation. However, bring it down to the basics, bring it down to Africa. How do you then, deploy this process within the confines of, the characteristics of mediation or the process itself? How do you use it in a way that enables parties arrive at the desired outcomes? So as a mediator, you understand what mediation is. You understand how it works. Then it then behoves on you as the African mediator, if you like, to know how to use it to get your parties to arrive at a solution. And I'll give you some scenarios. I've been in a mediation before where one of the parties didn't understand English, for example, and I found, well, the party understood English, but it was very limited. He was always devolving to his lawyer to explain, or the lawyer was always explaining. He would say, I understand, but I knew that he didn't understand, a lot of what was being said. Now, in private meeting, I'd asked, did he want an interpreter? And of course, he didn't want, to be seen as not understanding English. So he didn't want one. What did I do? With his consent and with the consent of the lawyer in private session, I spoke Yoruba to them throughout. For me, that's culture. Now understanding, the place for compromise is key. Because if I come into a mediation, yes, in African culture, we're supposed to be respectful. If I come into a mediation as a mediator and the parties are older than me, and I start to courtesy and courtesy and courtesy, because, I'm being mindful of culture, it takes away from you as the mediator. So, that's, the flip side of this issue of culture. Yes, we are very respectful and all of that. Now, if I was in a private room with that same senior party, there's nothing that stops me from courtesying to greet him or her. Do you understand where I'm coming from or what I'm trying to say?
I do.
Yes, I do. Yes, there's a place for culture. There are some things we should do. As a mediator, if you were in the North, for example, you understand that, women cannot look men in the eyes. They can't look them in the face. So it's difficult to have a female Hausa mediator who is mediating in a dispute with men, because that culture does not enable them. Look at a man, because, mediation says maintain eye contact, So it's important to understand, our cultural leanings and balance them as the mediator in Africa. So you can't say, well, mediation says that I must maintain eye contact, I should look at my parties, and then that in your culture, you're not supposed to look at them. If you look at them, they think you are rude. So how do you balance, things like that? I've been in a mediation once where in private session, one of the parties that he was an octogenarian, he had told me that I had found out that he found out the interest. He had told me what was driving his positioning, his hardening, was because he felt that the other party, was very rude and disrespectful. I mean, these are, I don't think, in other climes, those things will matter. But here it matters because it's our culture, because we value respect. We encourage respect. So once I knew this, I asked if he would like for me to mention it to the other party. And he said yes. And I was able to bring it to the other party's attention that this man thinks that he says that he knows your family and that you have come to this mediation pretending that you don't know him and you are speaking English. He expects that you should have greeted him in Yoruba, and all of that. Anyway, I communicated this to the other party as he has said. And the other party was completely taken aback because he didn't realize. And guess what? He told me he was ready to apologize. Now, this apology, when I said to I told the other party that he was ready to apologize. He said, okay. This apology wasn't just, I'm sorry, sir. When we came back to a joint session, because he had asked that I bring them back to a joint session, that he was ready to apologize, that there was nothing like that. When they came back to a joint session, this man went flat down in the traditional way the Yorubas greet the elders, a man to a man. He doubled, he went flat down on the floor to explain it to people who are not Yoruba speaking. Only in our clients, but did it result in a resolution? Yes, it did. That apology, the fact that the man saw this other party as not being arrogant anymore by way of that apology, got them to resolve that dispute that day. Will you be taught this in an international mediation training program? No. Will anybody say, oh, do not allow parties, go to that extent? It's not about apology, but how do you apologize? Understanding the cultural requirements of people. Because as a mediator, when you understand the cultural leanings and the cultural nuances of parties, you're able to then guide them. Because I understood it, I was able to then guide the other party to say, look, this is it, as a Yoruba person to another, that this, is a requirement and this is a big issue. So there's a place for culture, in our clients, because there are things that are expected of us culturally. There are attitudes and mannerisms. There are ways or things that people read more meanings into, that ordinarily would not matter, generally. But it doesn't then say, oh, there's an African, type of mediation or, otherwise. No, mediation is universal in terms of the process, in terms of its leanings and its expectations. Now, in guiding parties as the facilitator, there is a place for you with knowledge and understanding of the cultural leanings of the parties to guide them using those cultural leanings to arrive at the desired outcome. That's my.
Wow, thank you so much, Mr. Simon. For the first time, I've been able to get an answer that has led to rest this question. So, Abby, can you please take the questions in the comment section, please? Can you do that? Thank you. You're on mute. Yes, you can
Can you hear me?
Natalia.
Okay,
Fantastic
great.
response. Yeah, please continue.
Okay, so the first question is from Althea, and it says, basically it says how to deal with deadlock. Let me look for it. I had it right here. Okay, I seem to have missed it. Okay, here it is. Oh no, that's not. I read it and it says she was asking about how to deal with deadlock and power imbalances.
Okay. Right.
Yes.
Dealing with deadlock in mediation, as you would always have, it's common to have deadlock in mediation. One way for me, dealing with a deadlock is to pause and, do some reality testing. Because sometimes the reason why there's a deadlock is because parties do not really understand, the issues. They don't understand, the alternatives that they have. Sometimes they're just being positional, So, I would say, do some reality testing. Ask the parties what their alternatives are. Sometimes they're ignorant of the benefits. Sometimes, they're ignorant of the prolonged, the drawbacks of, prolonged litigation. So sometimes the lawyers even tell them, let's go to court. We have a good case, So as a mediator, it's important to understand, what is causing the deadlock and play the devil's advocate. Do some reality testing. Ask them what the alternatives, in court would be, because like I said, it may just be for want of, it may just be because they feel they have a better case. So, do some reality testing. Again, I always say, in handling deadlock, I always sometimes just allow parties, I always give them a break. I always say, let's take a break for 30 minutes, so that parties can calm down, and, have a rethink. Give them, call a break for 30 minutes. Sometimes you can even ask that parties come back the next day, depending on the situation, because remember, it's not always a one-size-fits-all, cap. Different situations call for different actions, but it always works when you call a break. It's like when you're working on your computer and you've been sitting behind your desk, typing away on your computer for a long time. Sometimes your eyes become foggy and you can't really see well. So we always say, step away from your computer, walk around the room, just go around, talk to somebody else, do something else, pack it up, and then come back. I always advocate the same thing in mediation. Call a break, take a break. Let the parties, don't even talk about the dispute. Let them do something else, and then come back maybe in an hour, maybe in 30 minutes, maybe the next day, and start again. I find that this always helps. So in addition to reality testing, playing the devil's advocate, helping them understand the real issues, because you must help the parties understand the real issues, because you've listened to the two sides. You've seen the big picture. As the mediator, you've heard both sides. You might even have seen or heard some things that both sides, have not even really paid attention to. So it helps steer them in that direction, by playing the devil's advocate, do some reality testing, help them understand, what the alternatives are, and the likely outcomes, and then call a break. So, that's how I would advocate that you handle deadlocks. And then power imbalance. It's important for you as the mediator to first of all not be intimidated by that power. When you recognize there's an imbalance in the room, power imbalance, always recognize it and address it. So for example, you have a senior advocate representing one party, and then you have maybe a junior lawyer representing the other party. And, of course, in that kind of scenario, the senior advocate will come with the authority of the senior advocate, and there would always be an imbalance, because if the senior advocate is very vocal and, always wanting to do the talking, then, there will always be an imbalance if the other party feels intimidated and does not want to talk. So as the mediator, you must recognize this imbalance and not be intimidated yourself, such that if the senior advocate of Nigeria, for example, the SAN, is out of order, you are able to call the SAN to order. So the other side is not intimidated. And I say this, I've been in a mediation before where, an SAN who had never been in mediation and he had made it clear from the beginning, he didn't want to be there, he was forced to be there, and he just wanted to say he had come and he wanted to leave. I had to allow, and he was, an elderly person. I had to bring everything, every skill in me to the fore to stop myself from being intimidated, because he had gone on about not wanting to be there, and he didn't want, and in a very loud, manner. And the lawyer on the other side was very quiet and couldn't say anything. So I knew immediately that there was an imbalance. And if I wasn't careful, if I didn't handle it carefully, I would be intimidated as well. So, it took everything in me to rise up to the occasion, to acknowledge him respectfully, but remind him about mediation and the essence of being referred or mandated to mediation, and that since he was there, because he didn't want to stay for the mediation, and that since he was there, it was in order for him to give mediation a chance. And then I went on to remind him about the, expectations in mediation, and that mediation was parties driven, it was about party autonomy, and that he needed to allow his party to do the talking, and that I would be very grateful if he didn't do the talking anymore. He was taken aback, but I told him, and that anytime he spoke, I would need to balance it with having the other lawyers speak. So I was very clear, in trying to balance it, and then, get him to, be less vocal and less adversarial and less, aggressive. And it worked. If I'd allowed myself being cowed or intimidated because, of his position, then I would have done the process an injustice, and I would have done the other party an injustice. So what's important in handling power imbalance is to be sure, as the mediator, that one, you are not intimidated, and two, you are able to call the parties to order, such that what you do with the party who is, sucking the power, you ensure that you do with the other party, and make sure you say it so that the other party is empowered to want to, be at par with the lawyer, for example, who is being very vocal, or the client who is being very vocal. So you must balance it. If you say speak for 5 minutes, if the person who, is being very vocal,
Abby, she's frozen.
I'm going to allow you to speak for 15 minutes as well. So that's basically it. So that's
okay then. Thank you so much.
Okay, I think Althea had her hand up, but I think
you had your hand up. Do you still want to say something?
No, because the question was subsequently answered. The question on unequal power between the parties. So thank you.
Okay.
Thank you.
You're most welcome. Thank you so much, Mr. Simon. What are your final words to everyone listening to you today? Like I said, we have a cross section of mediators, mediation advocates, end users, and consumers. What final words you have for them on the business and the practice of mediation, and those who would like to follow in your path before we wrap up for the day?
Okay, I would like to use a quotation from John Maxwell that I like to use. I'll start from there, and it says, one is too small a number to achieve greatness. One person, one is too small a number to achieve greatness. How do I say so? As mediators, we need to band together. We need to work as a team to promote the practice of mediation. We need to help each other. We need, it says, iron sharpens iron. We need to help each other, hone each other's skills, have, breakfast meetings, if you like, where, us practitioners can come together, and talk about, our mediation experiences and learn from each other and learn from each other's experiences. It's very key. I mean, I'll say this quickly. I mean, our firm, like I said, fully commercial and fully ADR, full service ADR outfit, has what we call Open Mediation Center. And in this center, we've been able to bring together mediators, arbitrators, and by the way, I have arbitrated in a dispute, I've, handled an arbitration dispute, myself. So, I'm not, only a mediator. I've done arbitration before. It's just that, when you try to balance it, you know which one works, best and which one you are more passionate about. So, we've been able to bring together mediators, arbitrators, lawyers, cost experts, to, like I said earlier, deliver early intervention in business disputes. This is very key. Now, mediation, I would say, is now an established trend. When we started, as mediators way back, at least when I, became certified in 2004, mediation wasn't as accepted as it is now. Mediation is gaining momentum. It's maturing. It's now, more known. Lawyers and parties, are a bit more aware. Lawyers are now more aware. Lawyers don't think the A in ADR means arbitration any longer. It's now being a more trusted and versatile, profession, if you like. In fact, now it's now being regarded by some as an independent profession. So users are waking up. You now have repeat users, for mediation. People now realize that mediation can really help, them to achieve their needs, their goals, get results, and of course, that, they spend less time in it, it helps them save face, it helps them save face, there's less risk. So it's important, for us to keep, the mediation gospel going. It's important for us as mediators, to increase our skills and our expertise, increase the experience, because I dare say, as we increase and acquire more skills and our experience, balloons and grows, the more successful mediation is. It's not there yet where it should be, but I believe that with time, mediation will take its pride of place as a dispute resolution, process, as the mainstream, process, particularly, like I said earlier, for specific type of transactions or disputes, commercial disputes. Even arbitration institutions these days, have embraced mediation, more enthusiastically. You find that, they now, have combined arbitration. So for me, what are the trends? I see, trends. One trend that I believe so, much in is a trend of the mediation advocates, which is gaining ground with training and skills acquisition. There's a place for mediation advocacy. You just have to, you have to, as a mediation advocate, understand mediation and how to support the mediator. You understand mediation process, understand how you can support the mediator. Know that you're not just going to sit down there to object to your being there, but know what your client wants and how you can use, mediation to help your client achieve the desired outcome. So it's not just about just going there, I'm just a lawyer representing, but, it's going there and knowing that you must understand, what your client wants and what the other side wants, and support the mediator to enable those parties, arrive at, the desired outcome. Two, well, another thing which is very important is, what I always encourage is specialization. We must specialize. We must carve out niches for ourselves. We must, be subject matter competent. Don't be a mediator who wants to do everything. Be a mediator who is skilled in a particular area or in particular areas. And before you know it, you will be known for that area. Because what do clients want? They want, desired outcomes. They want consensus. They want win-win. They want to achieve their goals. So yes, mediation helps parties achieve goals, but, we also must, as the mediators, must understand what it is that, we are doing, such that we set ourselves up to be the best. I always say that, I learned recently that there's a difference between subject matter expertise and subject matter competence. Subject matter expertise means that you went to school to learn to be a lawyer, or you went to school to learn to be an accountant. So that can be taken from you, regardless of the fact that mediation is open to lawyers and non-lawyers, alike. There are things that you know as a lawyer that somebody who is not a lawyer, or there are skills that you have as a lawyer that someone who is not a lawyer would have. But focus on being, subject matter competent. Your clients want to know what you have to offer, what value. We must be concerned with adding value to our clients, and that's why if you have an understanding of mediation, you will understand how to use it. You don't have to wait till there's a dispute before you use mediation. There's something, that I do now. It's called deal mediation, and it's using mediation, before using mediation to help your client or the parties arrive at the desired deal that works best for them before a dispute occurs. Now when you help your clients, when you add value like that to your client, there's no way, they will not, come for repeat business. There's no way, you won't get more patronage. So it's important, that we add value to our clients. Another thing that I would say is, and I don't want to say think outside the box, but it's important, while we focus on the facilitative style, to understand where there is a need for mediation. So when, because I'm talking about future trends now, when, you use hybrid forms, because there are different types of disputes that require different, responses. Yes, the facilitative style is what we practice, but there might be a need, to introduce the evaluative style sometimes to help parties arrive at the desired outcome. And that's why I made reference to the gossip approach, earlier on. Yes, and then, like you have in the US law firms, where, a lot of law firms are into consultative law practices, with consultancy and training, focusing on training. My take is that, we try to do, to be versatile, such that in our practices as well, we are open-minded, whether we are ADR experts or, just litigators. We're open-minded, to flow with the times, go with trends, and, try to, offer these consulting approaches, to your clients and help them, develop their manpower, particularly in the area of ADR. Nowadays, you have many organizations that have ADR departments. It means that ADR is catching up. So what do we do? Do we just sit back? How can we play in such organizations? Where do we want to play? Do we want to wait for it to come to us, or do we want to go to them? So it's important that we're able to go, with the trend, with the trend, and try to be of value to our clients, by being versatile and helping them, by creating value for them at the end of the day. So
okay, thank you so much, Mr. Osarieme. Now, I need to crave the indulgence of those listening to us to please just give us extra 10 minutes, because I won't be doing justice to having Mr. Osarieme here without asking us this very important question, because it has to do with mediation advocacy. I'm trying to see how in less than 10 minutes we can get your thoughts on this particular point. Mediation advocacy seems to be that underrated cash gold mine in mediation that a lot of people don't even look at, in the sense that, the way the whole African Nigerian concept is, when parties come to meet a mediator, they come to meet a mediator with the mindset of having a dispute resolved, with the mediator being on their side, not necessarily being neutral to both parties. But I don't want us to go into that. I don't know. I'm sorry. Can you hear me clearly?
I can hear you.
Yeah.
Loud and clear.
Okay, great. So my question is this: for the sake of time, Mr. Osarieme, please, can you just shed light on the gold mine in mediation advocacy? Because a lot of people are just focused on a stream of income from mediation, being a mediator, without even looking at the gold mine of mediation from a mediation advocacy point of view. Because when people come to meet you, like I said, they come to meet you with you expecting them to represent you. When people want to go into mediation as a practice, don't know that there's more of a stream of income coming from mediation advocacy than being a mediator itself. So I don't know whether there's a way you can just briefly capture the thoughts of mediation advocacy from the stream of income for those listening to you right now. Thank you.
Okay, I would use this analogy. The thing is, like you have litigation advocacy, you have mediation advocacy. Representing your clients in mediation these days doesn't require that you just go there and you play a passive role as the lawyer. It doesn't require that you go there and be adversarial and say, I don't want to be here, I don't understand this process, I think it's a waste of time, I think we should go back to court. No. Mediation, as we know, has, its advantages, and, we're not yet, time will not permit me to state all of the, additional advantages. You can use mediation for big infrastructure transactions, construction transactions, all manners of transactions, apart from criminal cases, of course, and, election cases. So, there's an opportunity open to lawyers, to act as advocates in mediation, Now, there was this, there's this well-known story of the lawyer, the litigation lawyer, who had been in court for several years and had sent his son to school, from his fees, appearance fees. And when his son graduated, the son came and said, oh, I think we should resolve this by mediation. And he resolved it. And the father was furious, saying, who told you to resolve this dispute by mediation? This is the dispute through which or by which I, sent you to school. Now, what did that lawyer realize? He realized that as a lawyer, what did that son realize? He realized that as a lawyer, there was a place for mediation or for his skills as a mediation advocate to support the process. Now why did I say this? As a mediation advocate, you can handle 5-10 mediations in a month, if you like, and make money as an advocate, than being in litigation or being a litigation advocate and just keeping a matter in court, dusting the files for years and years and years, and wanting to go to your client for appearance fees every time, the matter, will come up in court. There is such a big role, there's such a big opportunity, there's such a big responsibility on the shoulders of the mediation advocate, because once you understand, that in mediation, your parties stand a chance, or your party stands a chance of resolving the dispute and getting the desired outcome, then you go all out. Because as a mediation advocate, you must first understand your role. The fact that you take back seat and your client takes front seat shouldn't be a put-off. It shouldn't, get you, out of mediation to say, I'm not in control and I want to be in control. No, there is a place, for the mediation advocate to support the mediator in the role of helping the parties arrive at settlement. And this is the gold mine that Fola, refers to, is referring to, because once you, the mediation advocate, comes to a mediation prepared, understanding your client's case, understanding what your client wants to achieve, then you are all out to help the mediator make your client achieve or make both parties reach the desired outcome. But if you do not understand it, then you will be doing a disservice to your client, because first of all, if you do not understand what your client wants to achieve, the process will be of no value or of no benefit, to your client. But once you understand this and you're able to get the process to work in your favor or in your client's favor, Understanding also the other party's point of view, because it's not, about your client alone. Understanding that it must be win-win. There must be there must be consensus. There must be a meeting of the mind. Also considering what the other party wants to achieve and getting parties to negotiate and shift position. Then, you get the desired outcome and you move on. You get paid and you move on. And what else do you want? You want to do more. And once you're able to add value to your client as a mediation advocate, that's it. The client will come back to you for repeat business. The client will spread the word that, oh, this lawyer, can help you do this, get this matter resolved in mediation. And that's what you want. And that's how to grow your business. That's how to grow your reputation, and get the value out of mediation as a mediation advocate.
Wow, thank you so very much, Mrs. Osarieme. It's been an interesting, explosive, and insightful session with you. We've learned so much, and we thank you for the gift of your knowledge and the gift of your time. Thank you so very much. Really appreciate this. And a big thank you to my Lord and every other person that has tuned in today, and Althea Thompson. Althea Thompson, where are you from? Is it?
Oh, I'm from Trinidad and Tobago. That's in the Caribbean.
Oh, okay. Are you a mediator too?
I'm a certified mediator, but I do essentially voluntary work. I'm an attorney at law and was an in-house attorney at work for quite some time, and I included mediation in my dispute resolution clause in most commercial contracts.
Okay, thank you so much. Okay, so thank you so much for
Thank you very much, Paula. Thank you, Milord. It's good to see you here. And thank you, Abby. Thank you to everyone who's been who's tuned in. Thank you for having me. And like Althea has said, one very important thing, which I always, just one last comment, which I always emphasize, is to always ensure that you include mediation in your dispute resolution clauses, and have a full-blown dispute resolution clauses that recognizes negotiation, mediation, and arbitration. Is one thing that we never fail to teach or talk about in, as a firm in local partners. So it's something that I always encourage people to have. So thank you very much for that last moment.
Thank you. Yeah, thank you so much. Abby, do you have anything to say before we call it today?
Just to say thank you to everyone. We appreciate you. Thank you so much. Mr. Osarieme, I didn't expect anything less.
Exactly.
Thank you so very much. Thank you. We really appreciate this.
Thank you for the privilege. Thank you for having me. Thank you.
You're welcome. You're welcome. Thank you so much. Thank you, Althea. Thank you, Fumi. Thank you, Kichuku.
Thank you, everyone.
Thank you, Lola. Thank you so much, everyone.
And we'll meet again next week, Saturday, prime time, 5 p.m. for another explosive session on the mediation hot set. Have a lovely weekend. Goodbye, everyone. Bye.